This program is brought to you by Emory University.
One of the wonderful things about the Kessler-Eidson program at Emory is that we bring in faculty from across the country, and among those faculty are a number of judges from across the country. And when you're in my shoes, or the shoes of some of the other faculty members, the shoes that you will step into when you graduate from law school and have to have, actually in some respects, a daunting experience. They sit up there on a bench, they look down at you, it's set up that way. It can be scary, but the notion that you can bring judges in a classroom to talk to you about what their life is like allows you an opportunity to get inside their heads. We talked earlier, at least in our group, about advocacy being a two-way street. One, it's what you say, but two, it's knowing your audience. And this is your audience. When you practice law and you appear in a court, this is your audience. So with regard to this particular audience, I want to use them to talk to us and answer questions from you about professionalism and ethics in the courtroom and through the litigation process. So let's introduce each one of our panelists.
I'm Matt Williams. I'm from King County, Washington. I'm a district court judge. That means I hear all felony first appearances. I try both criminal and civil jury trials. And I hear a lot of domestic violence cases.
My name is Cynthia Stevens. I'm with the Michigan Court of Appeals, which means that I'm in the Intermediate Appellate Court for the state of Michigan. We are elected by districts, but we serve statewide. We have jurisdiction over all appeals in the state of Michigan, including those from administrative agencies. I was a trial court judge for approximately 28 years.
And is there something else you want to tell them?
That I went to Emory in the class of 1976.
So she was one of you. And hopefully in another 10 years, one of you will be sitting here as a judge. Judge?
Good afternoon, everyone. My name is George Hanks. I'm a United States Magistrate Judge in the Southern District of Texas. I sit in the Houston Division. I've been a Magistrate Judge for 3 years. Before that, I sat on the Texas Court of Appeals, and then I was a state trial judge.
Good afternoon. I'm Jack Nevin. I'm a Superior Court Judge in Pierce County, Washington, approximately 30 miles south of Seattle. I spent 16 years as a district court judge. I'm in my second year as a superior court judge, and that's a general jurisdiction court, and I hear everything from major labor disputes, flash mobs at Walmart, to murder one and everything in between.
Okay, so let's get some insight into what their lives are like, starting with Judge Williams. First of all, you have a docket, which means that it's a listing of cases. How many cases are on your docket, approximately?
It depends on the calendar. An arraignment calendar, which would be a morning, could be anywhere from 40 to 150. And those are cases where individuals have to be advised of their rights, have to be made sure that they have assigned counsel, that they understand their rights, are presented with the charges, and we will do that number of cases within that time frame. A trial calendar, we could have as many trial sets, as many as 15 to 30 to start on the same day. Do they actually start on the same day? No, but that just means that they back up right behind those.
Okay, Judge Stevens, taking you back in time to when you were a trial court judge for 28 years, can you recall how big your docket was?
When I was a judge in a limited jurisdiction court, which was called a district court, I had, depending on when I had summary proceedings, I would manage 65 to 70 summary proceedings in a given day. When I had traffic, it would be about 150. When I went on to the circuit court, we maintained an individual docket. My individual docket was approximately 800 cases, no law clerk.
Oh, and I forgot to ask you, what about your staff?
We have recently instituted a process where I now work with a team, and the four of us, two clerks, basically an in-court clerk and me, we constitute a team. I do not have a bailiff. I do not have a law clerk.
Judge Hanks.
Well, federal magistrate judges are sort of the worker bees of the federal judiciary. I mean, we are extremely, extremely busy. We do everything from initial criminal matters, that is, everyone who is brought into federal custody will appear before a federal magistrate judge. So we handle all the initial criminal matters. We handle a large part of the civil dockets. We will have everything from securities fraud to accounting malpractice, civil rights cases, pretty much the entire civil docket. We will be handling the appointment or the impanelment of grand juries. We'll be issuing seizure orders in admiralty cases for ships at dock in the Houston harbor. Literally, if it needs to be done in the federal court system, magistrate judges are on the forefront of doing that. So our dockets are extremely, extremely busy.
About, when you say busy? How big?
Oh boy, hundreds of cases.
Okay. Are there things that you are asked to give a ruling on, areas of law that perhaps you didn't even study in law school?
Definitely. I mean, one of the areas is admiralty law, which is something that we do a lot of because of the Port of Houston's there. Didn't take admiralty in law school, but yet we have to know admiralty law. We do a lot of IP work in Houston because of the oil companies, not as much as the Eastern District of Texas, but a lot of it. So we've got to get up and be on top of that area of the law as well. So there's a lot of areas. I mean, basically, if it can be brought in federal court, somehow federal magistrate judges are going to be involved in it.
So would it be fair to say that if you have an admiralty proceeding in your court, right, and you've only been on the bench, the federal bench, what, 3 years?
3 years.
3 years, and your first admiralty proceeding, and one of my colleagues here gets in front of you, actually, with regard to admiralty, they're your student, because they're teaching you the law. You need to learn from them. Is that kind of a good way of looking at it?
That is a very good way to look at it. I mean, we rely, of course, the courts do their own research. We have our lawyers, but we rely on the credibility of counsel before us to help us parse through the law and address the difficult issues that are coming up. And how that's really important for you is that if the court needs to rely on you for the law and to help the court think through the problems, then your credibility with the court is critical. If you lose that credibility, you're going to have a lot of problems later on in the case convincing the court of your client's position.
Okay. Judge Nevin, let's get an inside look at your courtroom. Tell me about that.
Well, in terms of numbers, as a district court judge, pre-trial, post-trial, and trial, I had approximately 4,000 to 5,000 files cross my desk every 12 months. As a superior court judge, all of our judges have dockets anywhere between 650 and 850 cases. Mine somewhere in the vicinity of 700. We have dedicated dockets. So, for example, when I was on a civil docket, I would have up to 50 pretrial motions every Friday morning. Of those, anywhere from 5 to 8 could be motions for summary judgment. In other words, dispositive motions which could end the litigation. Of course, now on a criminal docket as well, I have motions to suppress, lots of pretrial motions in regards to criminal cases, the most vexing of which are multiple defendant cases with multiple counsel.
You know, for the last 3 days, students here, we've been sitting here talking and working on a problem involving securities transactions and lies to the government in the context of trading of stock. And Judge Nevin has been kind enough to come take his time and help teach one of the sections. Is that the kind of case that could end up in your courtroom, one of the 8,000 cases?
It could. And there's a lot of different ways in which it could end up in my court. It could be civil, it could be criminal, understanding that part of it would probably fall in a federal forum, but not necessarily. Keying off what Judge Hanks said in regards to law school curriculum, I can assure you I didn't take a single course on savings and loan crises legal issues when I was in law school. Yet we have a ton of those in the Western United States. I believe that advocacy is an enterprise in adult education. And I believe that you must educate that jury as you would a class, with notions of primacy and recency and so on. And I think the same thing holds true with a judge who needs to learn and has not had an opportunity. It's not implicit.
You know, my colleague Dick Reuben, who's sitting here, I asked him a moment ago before we started, I said, well, you know, you've been practicing for quite some time. How do you define professionalism? He says, well, you know, it's about how we deal with the court, the system, one another. And then he grabbed me as I walked away and he said, and don't forget the people who work for us. Please don't forget to say that, right? And I want to talk about that because we talk about professionalism a lot. But the reason I think we started off talking about the inside your courtroom, your work lives, because professionalism is also about making their lives easier, and at the end of the day, I think, and you can tell me if you disagree with me, getting a result that's beneficial to your client. What do you think about that, Judge Williams?
Well, I cannot count the number of times I hear counsel tell me that their behavior, which frequently is abusive to parties in the courtroom, to the court staff, to witnesses, to victims, that their behavior is justified by, and I quote, my duty to zealously represent my client. And in Washington State, we no longer have the canons, we have the RPCs, the model rules. And if you look at the model rules, yes, the word zealous is in the preamble. It is not in the rules, and there's a reason it's not there. You know, and that is because ultimately we are bound by issues that relate to respect for the parties of that are involved in litigation, respect for our colleagues, and we are bound to an understanding that justice is not served through abuse.
So you all took civil procedure and you understand in theory, right, the process of discovery, and somebody comes to your court, Judge Stevens, and says, I served a document request on this company and they're refusing to turn over documents. They say the documents are privileged. The law says I'm entitled to the documents. I've written them 13 letters. They've written me 13 letters back, and you see this incredible nasty exchange of letters. And you've got all these cases you're dealing with, and what do you do?
Discovery is the place at which most bad behavior is displayed. Whether it's people who are in firms like, I practice with the franchise firm of Hungry, and Starving, meaning that there were a group of us who shared office space and we were sole practitioners. So whether it's the sole practitioner or the silk stocking firm, that's the line in the sand. And as a trial judge on a Friday, apparently they like to end our weeks with acrimony, Judge, we would have motion day, and it reminded me, my mother was a retired kindergarten teacher, and so it reminded me of her kind of sandbox disputes. Now, it's not that the issues weren't important. It's just that people would decide that they had to go all gonzo, hardline, on whether or not they were going to disclose who the fourth wife was of the third defendant. I'm not going to let you depose my expert till I depose your expert, a kind of tit for tat sort of thing. What we as judges try to do often is to try to help counsel reach an agreement, just as we want parties to reach an agreement. So we did a lot of send you out in the hall, the playground, and play nice. Failing that, because most of this is discretionary, it is a complete discretionary call, but you find that what happens is you build a memory. You don't remember Ms. Jones as that fine advocate who had a case 3 weeks ago. You remember Ms. Jones as somebody who will not give an inch and who will always demand a quarter. Now, what difference does that make? That means that when you exercise your discretion, and a substantial amount of what is needed to make your practice life reasonable is discretionary, an adjournment, additional time, things of that nature. When it comes time to the exercise of discretion, the discretion is less likely to be exercised in your behalf. And when it comes to me now as an appellate judge, where I see a long history of discovery challenges, and my colleagues in the trial court have issued a sanction including the ultimate sanction of dismissal of a civil case or striking of defenses or claims, my standard is abuse of discretion. I see this long history. I don't see abuse of discretion. So it makes, by making the life of your colleagues difficult unnecessarily, you also make your life difficult, and your ability to serve your clients and to give them the kind of quality service that they deserve far less likely. In other words, you live in mess, you create mess, your life will be a mess.
Judge Nevin, we were talking earlier about, I guess, what I would describe as almost as buying credibility with the court by acting professional over the course of your career. And tell me a little bit about what that means to you and that how that works out in terms of how you view counsel in your court representing a litigant.
Well, you can engage in what has historically been referred to as the sharp practice of law. It involves a certain amount of abuse towards your opponent, a certain amount of trying to rationalize and circumvent or at least push the rules to the envelope. And in doing so, in a given case, you can prevail. But you can win a battle, but lose the war. Because if you're in my community, I'm going to know who you are. And I know the attorneys who I'll treat the same, but when one attorney, for example, my colleague Ms. Gallagher appears before me and says, you know, Judge, I'm having this problem on this issue, I'm going to say, okay, Ms. Gallagher. But if another attorney appears before me, one who I know has attempted to win some battles, I'm going to trust and verify, as the saying goes. I'm going to ask for a declaration. I'm going to think long and hard about what they're trying to tell me. And I can tell you that this occurs most often in civil litigation, not in criminal litigation.
Okay. Judge Hanks, let me throw out a little scenario for you. I have a bunch of students here, and in 2 years, let's suppose one of them graduates. They come to practice in Houston, and they're taking their first deposition ever, and they ask a series of questions, and the defense lawyer says, you can't ask those questions, right? I'm instructing the witness not to answer, and counsel, if you had been practicing law for as long as I have in this particular jurisdiction, you would know better, and you should behave yourself because you're going to be sanctioned, right? Is that a scenario that's perhaps uncommon, and how would you deal with that?
Well, unfortunately, you will find lawyers who will try to bully young lawyers. I mean, there's no question. Judge Nevin just passed me a note and said, it's happened to me too. It can and it will happen. But, you know, I think that you're a lawyer, you have the same law degree as someone who's been practicing 30 years or 40 years. You have your own professional responsibilities to uphold and adhere to, and you need to do what's right for your client and act in the best interest of your client. If that came to me as a judge and there was a dispute over that particular deposition, first of all, judges know what goes on. I mean, we were all trial lawyers. We've been in the trenches. We know the tricks that are played. We understand how parties try to take advantage of other parties. So if that happened, I would understand what was going on, and I definitely would not penalize that young lawyer. And the reason I'm saying that is you don't have to respond in kind. That is, you have your own professional ethics and your own standards to uphold. You don't have to go back and in his or her face and act unprofessionally just because to defend your client. You can still defend your client and protect the record, acting professionally and within the rules that are provided.
So is it a fair takeaway that representing your client zealously doesn't mean that you always have to or ever have to respond in kind?
That's exactly what I'm saying. I mean, just because the older lawyer or another lawyer, abuses you or tries to act unethically, long story short, I'm from a little small town in Louisiana called Breaux Bridge. And the way we learn lessons in small towns is through like little stories and parables. And one of the things that my dad taught me growing up in Louisiana that has applied to all of my law career and also as a judge is that he always said, never get in a fight with a pig because the pig will love it and you'll just get dirty. Okay? That really sums up what's going on here. Don't get in the mud with the pig. I mean, the only thing that's going to happen to you is that your reputation is going to be damaged, your client's interests are going to be damaged, and the other guy, because he's been doing this for a long time, he's already got a bad reputation. It's not going to bother him, but it's going to affect your credibility and your ability to represent your client before the court.
Okay, so taking the scenario a step further, I bring my client to the deposition. I'm this young lawyer, and I bring my client to the deposition, and the lawyer on the other side has obstructed the deposition, and my client's egging me on and saying, you need to do what he does. You need to give him tit for tat. You know, Judge Williams, you teach NETA, you teach the deposition program, you've taught at Emory for countless years. How do you deal with the client? Because you have a client problem as well.
You do, and there's theater that takes place every time the client is in the room, because the client needs to feel emotionally that you are doing your job competently and effectively. And of course, I will tell you, one of the things that I see in my courtroom is frequently attempts by counsel to embarrass the other counsel in front of their client. As a practicing attorney, I would see it in depositions as well. And the conversation that you have with the client in the hallway is the conversation, and I apologize to my friend from Texas, is usually that lawyer is engaged in Texas bargaining. And you have to understand that Texas bargaining is not effective. You have to understand that when it comes push to shove, that the judge that will review this transcript is going to see that we've taken the high road, and that we, as my friend Judge Nevin says, that we will win the war. That this battle that he's fighting, we're not even in the battle. That's his battle, and we simply move past it.
Well, Judge, I'm sorry. Yes.
Now, the reality is you're going to lose some clients by behaving well. That's just true. On the other hand, you're not going to get grieved by those same clients. And if it means losing a client to keep your license and your integrity, it's something you just have to get used to. There are lawyers who poach clients. There are clients who need more theater than they need representation. And it's up to you to protect yourself and protect the record when someone acts crazy. What I would train students to do is someone is blowing up and they're yelling and they're screaming and they're whatever. Hopefully, because most depositions now are done by videotape, the videotape is going to hear you get quieter and calmer and repeat, so you've told me that you are telling your client not to answer this question, not based upon any privilege, but based upon your opinion. And they're going to blow up some more, and then you go, and you will not allow him to give the answer to this question conditionally based upon, and allow the judge to decide if it needs to be stricken. And they're going to yell some more. And then you just go, thank you. Because most thank yous you hear in court, as you know, are sarcastic.
Thank you, Your Honor.
On the flip side of that, where you are there and your client is the one that is being subjected to the abuse in the deposition or in court, and you do have a job to do there. You are not, in those famous words, you are not a potted plant. You have a job to do to make sure that you make a clear record. That does not mean that you stand up and engage in fisticuffs. It means, as Judge Stevens says, that your voice becomes calmer and calmer and calmer until ultimately, again, if the abuse continues, there may be the point where very calmly you advise the other counsel that the deposition will be recessed until the issue can be resolved.
Let me throw out another scenario. You're in court, and you know that the lawyer on the other side has said something that's false, right? And there's this tension, I think, that lawyers feel sometimes about personalizing the dispute with their opponent, as opposed to limiting the dispute to the dispute between the parties. And so I want to ask you, Judge Hanks, do you see this where it becomes personal in court and on the papers? And how does a judge react to that?
Well, unfortunately, some lawyers have a problem with drawing the line between what they're doing for their client and personal disputes with the other side. I mean, it happens all the time. Basically, when that happens in my court, I tell the lawyers, I ask the lawyers to step back and think about what they're saying. Typically, well, first of all, it's bad form in any court to talk directly to the lawyers in argument. You shouldn't be arguing between yourselves in front of the court. You should be directing all of your comments directly to the court. And if you find yourself talking directly to the other lawyer and addressing arguments to the other lawyer without addressing them to the court, you're probably getting into a problem right there. I mean, you probably crossed the line, and you're probably getting into a situation you don't want to be in. What I typically tell the lawyers when you see that happening is, think about this is outside the courtroom, but if I'm advising lawyers on this, think about not what you're saying, but what the court's hearing. Most lawyers talk to the court, and they're only thinking about what they're saying, but they don't really focus on how the court is perceiving what they're saying. I think if more lawyers would think about how the court is perceiving what they're saying and less about just what they're saying, they would realize that some of the things that they're saying and telling the court are inappropriate and unprofessional.
We've been talking about professionalism. You learn professionalism in law school is how you should deal with each other. And to some degree, I think I learned it is it's just nice to be nice. But the story I'm hearing also is it's not only nice to be nice, but it helps the client. It actually may help you get a result. It may improve your reputation. Am I getting this right, Judge Nevin?
Absolutely. The most successful lawyers in our community are the ones that are the most civil. They're the ones that treat their opponent with the greatest dignity and respect. And they succeed, and they have a ton of credibility. And they're easy to listen to. They're easy to listen to for the court because I don't have to be a lion tamer with them. I don't have to tell people, don't interrupt. I can just listen to the facts, and then the facts can be applied to the law, and then, hey, we can arrive at a verdict, which is what we're supposed to be doing in the first place. And anything else gets in the way of it.
So what I also hear, you have so many lions in your zoo, you don't have enough time to tame them all if you wanted to.
Well, my technique, I draw upon some prior experience, and I'm able to tell them in gentle but firm terms that there's only one person that's in charge of this courtroom, and it's me. And from that point on, that one party is not going to be interrupting the other party. And that they're going to eliminate their personal attacks because they don't lend themselves to any sort of fact-finding and therefore conclusions of law, particularly in a bench trial. And I use that as an example because family law brings out the absolute worst in attorneys.
And probate.
Oh, goodness, yes, absolutely.
We've been talking for a bit. I'm sorry? Yeah.
Corollary to that, and it is generational. It is a generational change because of the way in which technology has changed the way in which we communicate. Specifically, text messages have brought us to a place where we communicate instantly and we communicate in short chunks of data. And I see this in this context. I have advocates who have fewer years on the planet who are used to receiving a short chunk of information and then instantly being able to respond to it, and, as Judge Nevin would say, not waiting their turn. They want to interrupt because they've heard something that they think is wrong and instantly respond to it. And, of course, that is disruptive to the flow of the courtroom. And so part of what we wind up doing is having to say, no, counsel, talk to me, okay, not in the chunk, but wait, and I will give you an opportunity to fully and completely respond.
Okay. Judge Cynthia.
Assuming that you're in a courtroom and someone has said something that you know to be false, You do have an obligation to immediately deal with it. Now, the question is how. You can deal with it by virtue of pointing out to that individual that that individual has said something false. You could say to the court that that individual said something false. Or you could say to the court, Your Honor, there is no record support for the following assertion. That lets the court decide how to manage it. But at the moment where you are in a courtroom and you are alleging that your colleague has engaged in breaches of the rules of professional conduct, you have obligated yourself, and you are obligated, to report it. Because the court isn't going to manage that breach.
The phrase, there's no record support for that assertion, it strikes me. And the reason it strikes me is because you've done a masterful job of taking the lawyer out of the equation. And if the lawyer needs to be in the equation, am I getting your strategy right? It's the judge's decision, not yours as the advocate.
Absolutely. And again, it's a method of bringing down the temperature in the room.
And we've talked about hyperbole and conclusions and the use of facts, and I guess this is kind of along the way of just laying out the facts and letting the court figure it out. It's the court's responsibility in this case, right?
Yes.
Okay. We've talked for about 30 minutes or so. We have a bunch of students in the room. Does anybody have any questions? And I'll make it an open forum, beyond professionalism, beyond ethics. You have 4 terrific judges. You're going to be doing bench trials in the next day. You're going to be doing jury trials. Any questions that you guys might have for them, it is an open forum. Anybody? Anybody? Okay. Yes, of course. Here you go.
Thank you. When we're dealing with bench trials as compared to jury trials, and of course, unless under certain circumstances you're supposed to cover law, what is it that you really want to hear as a story we're kind of presenting within an opening?
I'd like, Reuben and I talked about this a little while ago, and I think I may have surprised him with my response. He said, how do you want them to prepare differently for you than for a jury? And the answer is, I don't want you to prepare any differently. Obviously, I don't want you to have jury instructions and so on, but I don't want you to presume that I'm an expert in admiralty, or frankly, a lot of other subjects. But here's the scenario. Think about who your listener is. And that's that notion of adult education. I may have just completed a murder 1 case or a 7-defendant car theft ring case. And this is my first day that I'm open. And my colleague, Judge Williams, is still in a case, and your schedule for him is going to go to me. I don't know anything about your case. I don't know a single thing about it. And I want you to be prepared to educate me with a good, solid trial brief and your motions in limine.
Judge Hanks, I don't want to presume anything, because that's not what I'm supposed to do. But let's assume for the moment, it may be true, that your situation is a little bit different. Case gets filed in the United States District Court for the Southern District of Texas, Houston Division, and the parties choose to proceed before a magistrate, and you're assigned to the case. And let's assume for the moment that you have the case from the filing all through the trial, right? And the parties have done discovery, they've had discovery disputes, you've ruled on motions to dismiss, motions for summary judgment. I gather you're familiar with the case to some degree, right?
Yes.
And now, what about this question about openings on the bench trial?
Actually, I got to agree with Jack on this one. I'd like you to tell me, I don't think you prepare any differently other than the fact that you don't need to spend a lot of time, well, you shouldn't anyway, in opening, telling me about the law or the burden of proof, okay? Because that's something that I'll already know. I'll know the burden of proof. That's pretty straightforward. As far as the law, tell me where it is that you're going and what it is that I need to be focused on. But, save the detail for later. I mean, basically, my kind of theory and in practice for the young lawyers is when you come before me, there are 3 things that I need to know, okay? What is it that you want? What's the law that entitles me to give you what you want? And what are those facts and just those facts that entitle me to apply the law in your favor, okay? When I'm processing the information on the bench, that's what I'm listening for, okay? whether it be a motion, whether it be a trial, I'm processing that information to try to get to a resolution of the case. The easier it is that you make it for me to get the law, the facts, and what it is that you want, the easier it is for me to rule in your favor.
Okay, so you have a young lawyer, and I assume you're going to have some kind of pretrial conference before the parties convene for the trial. And the young lawyer has this question. And is it okay for her to say to you, Your Honor, I haven't appeared before you before.
Oh, yeah.
How do you want me to handle this? What are you looking for?
And that's a very appropriate question, because even looking at the bench book, you're still going to have questions about how a judge conducts a trial. I would tell the young lawyer, look at the bench book, look at how I like to have the case prepared in terms of exhibits and all. But again, I would give them the same advice in that what I'm trying to do is reach a conclusion with respect to the facts and the law. The easier it is for you that you make it for me to figure out what the law is and what are the relevant facts, the easier it's going to be for me to rule in your favor. The more stuff that you throw out at me that's unrelated to that, all what we call in Louisiana the lagniappe, extra stuff, that's going to make it harder for me to understand your argument. And what's going to happen is I'm going to turn from your case to looking your side of the story to looking at the other side of the story and see if they can explain it to me better. So the clearer you can make the issues for me, the clearer you can make the law for me in terms of briefs, in terms of your arguments to the court, in terms of your presentation of the evidence, I'm going to look to you I'm going to look to your briefing and your presentation to guide me. The minute you get away from that, then I'm going to turn to the other side.
Bench book. Bench book. You said bench book?
Bench book.
Okay, tell us about that.
Okay. In most jurisdictions, in most federal court jurisdictions, there's a bench book. And what the bench book is, it's a collection of, it basically has a section on every court, every judge in a district, and it has the judges' likes, their dislikes, local rules, if they have any specific local rules to their court. Also, how they like things to proceed. Like, for example, on discovery motions, before you file a motion for sanctions or a motion to compel, in my court, my preference is that you, after consultation with the other side, that you prepare a letter to the court outlining the dispute, and we have a telephone call to see if I can resolve that dispute informally. If I can't, then you go forward and file a motion to compel, but typically when I get the parties together on a telephone call with knowledge of the issues, I can work it out, saves the parties a lot of time and money, saves hassle, but that's one of my local rules. So that's what the bench book does. It collects all those rules for each court. So in addition to knowing the local rules of like the Southern District of Texas, you should take a look at the bench book that will tell you a lot about, for example, your question about preparing for a bench trial. That's one of the questions that's answered in the bench book.
And so this is all about knowing your audience, right?
It really is.
And you can't communicate unless you know how your audience wants their information received, right?
That's exactly right.
Okay.
And the principal conduit for their audience in state court, there may or may not be a bench book, but there is always a court clerk.
Right.
And having decent, courteous relationships with the courtroom staff will make your life ever so much more easy.
He or she who controls the paper controls the world. And, the folks that handle the paper in the courtroom, are probably the most important people to your day-to-day life as a trial lawyer. And a lot of young lawyers overlook that.
Always be nice to them.
Yes.
Any other questions?
But do not try, let me take this
sorry.
another step though.
Yes.
There's another step beyond this, okay? And I'm just gonna be the more practical and probably rude one. Those of you who flirting, this is not being nice. This may be insulting and backfire.
Chances are you are not as attractive as you think you are.
Gifts are violations of court policy. So we're talking about a level of professional respect. We're talking about speaking to people. You want to give somebody a birthday card because it's their birthday, that's different. You don't give them a bottle of Moet.
Anybody? Yes.
As just wanted to ask, what is the most common mistake that young lawyers make in your courtroom, and how can we avoid it?
They don't know what they want.
Right.
They cannot articulate what they want me to do. And so they argue, and they argue passionately for their point, and I'm trying to follow where we're going, because ultimately I have to decide something. and there is frequently this point where I will look at them and I go, and what do you want me to do? And there's this flummoxed expression when they realize they don't know. And so if you know your North Star, you know what your desired end state is. You know, Jack, how is it you put it?
I can follow you if I know where you're going.
Yeah.
If I don't know where you're going, I'm going to be a half step behind trying to catch the back of that bus.
Tell me what you want.
So you would say that you're a judge, not a therapist. You don't entertain complaints without solutions.
Well, there is a therapy component to what we do. And frequently a mediation and frequently a de-escalation. But, start with, just right up front, tell me the decision you want me to make so that I can put whatever you're telling me into a context. Because otherwise, I'm going to sit and listen, and I'm going to try and follow you. But if I don't know where you're going, I'm going to get lost.
I would say that one of the other things is the failure to remember that we have 2 ears and 1 mouth, and to engage in active listening. Oftentimes, the young lawyer is so concerned about where she needs to go that she doesn't hear a concession or an agreement from a colleague, does not hear a witness make an admission that is useful in the course of an examination, doesn't hear a judge say, wow, I think I've got it. Or my worst case scenario is we would have motion day, otherwise known as the ninth circle of hell. And a lawyer would start talking, and I'd start out by saying, here's what I understand the dispute to be. Here are the 2 issues. Could you address them? They would either address something else, or later, after this had gone on for a while, I would say, do you feel compelled to share more? And they would keep on talking.
I was kidding to say it better. Another saying from Louisiana, when you're winning, shut up, and when you won, leave, okay? I mean, basically, as lawyers, we've done all this preparation, okay? We've worked the case up, we know the case law, we want to tell the judge everything we know about the case, but if the judge is asking the other side all the questions and beating up on the other side, you don't need to pile on. I mean, young lawyers will want to add everything. It's like, yeah, judge, what you said, and that's right. And jump in and tell the judge to show the judge how well they know the case. Well, when you're winning, shut up. It's okay. And then once you've got the ruling in your favor, act like you've been there before. You don't have to sit around and, high five the court or whatever. I mean, basically when you've won, you leave. But before you leave, be sure you get an order signed.
Shall I prepare the order or shall you, Your Honor?
So when you're winning, shut up. When you won, leave. But before you leave, be sure you get an order signed, ruling in your favor.
Your advocacy supplements your written materials. We read your written materials. Honest, we do. And I'm not sure that advocates, and perhaps more so young advocates, appreciate that, and they decide they need to go through chapter and verse of everything that's in their brief. Sometimes I've said, no, I've read your brief. Really? I did. and then, and so I think that's part of what we see too in this motion practice. And the motion practice, you've got maybe if a big docket on a Friday morning, you've got maybe 18 minutes to make your point. And you really have to be efficient. And, and spending 10 of those minutes on the history of a sumpsit is not going to be efficient.
May I add to that as well, that we will read your brief. We strongly recommend that you read your brief. I wish I was joking.
No, and this has to do with the fact that the time from when you wrote the brief and when you argue the case is going to be substantial, and a lot of life comes on in the middle.
What are you hearing here? What am I hearing? I'm hearing that a big part of advocacy is writing. And writing is important. It's just as important, if not more important, than being able to stand up and speak.
And if I might add, civility in writing. My biggest surprise in a court of general jurisdiction was the lack of written civility. It is not persuasive to me when one advocate in writing wants to question his opponent's lineage. It just has nothing to do with the case.
So much so that recently, a lawyer's description of an occurrence in a Michigan court cost that lawyer, not the client, cost that lawyer $20,000.
Yeah.
We have time for just a few more questions if we have any. Anybody? Yes, I know you've been waiting for this one. And because of the time frame, I'm going to do this. I'm going to invoke, there's some rule they have on television. It'll be 30 seconds each to answer whatever question is posed.
So tomorrow during this bench trial, some of us are going to have to do clothings, and nobody's told us how to do that. So if you could tell us what you're looking for in a 7-minute summation, that would be excellent.
And not take 7 minutes to tell us that.
Okay, we each have 30 seconds, Jeff.
Yeah.
Give me a logical inference of the evidence that has been admitted with a view towards what conclusion I should draw as a result of those inferences and that evidence.
I couldn't say it better. I mean, that's exactly what you need. I mean, tell me the facts that were established during the trial that lead me to reach the conclusion that you want me to reach.
Judge Stevens.
Why should you win?
Judge Williams.
The difference between opening and closing is that in opening or in closing, you get to argue the law, apply the law to the facts, and you get to explain and infer issues of credibility of the witness. You don't get to express a personal opinion, but you get to talk about credibility. That's the difference.
Any other questions? Yes.
Could you briefly give us some advice on the wide, like the difference between being a pushover on one end of the spectrum and being overly aggressive on the other end?
Actually,
we want to have a healthy middle.
Maybe I could ask two of the judges to do a role play. I know that Judge Williams likes to do that. Can you think of something?
Well, the way I was going to respond to that under the 30-second rule was going to be this: hard on substance, soft on people. The best negotiators are hard on substance, soft on people. Respectful, but firm. Respectful, but firm. So in terms of a role play,
do it with yourself.
You can do it.
So let's say the issue is we disagree over whether or not the witness, and we're having an oral argument in front of the judge on a motion, midterm motion, as to whether or not the witness actually said that the event occurred in my county, in the county that it was supposed to occur. Okay?
There is absolutely nothing in this record that says that happened in this county. I have no idea why he's doing it this way. We all know that's ridiculous. We all know it happened over in Gwinnett.
Your Honor, while it's true the first time the officer saw the defendant, he was in Gwinnett County. The reality is we have evidence that the defendant traveled.
Were you there?
From King County into Gwinnett County, and that is sufficient for it to be submitted to the jury.
His speculation takes it to the jury. Okay.
Thank you, Your Honor.
And with that, I want to say primacy and recency, start on a high note, end on a high note. Good luck tomorrow. Thank you, all of you.
Nicely done. Nice.